This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to the Court of Appeals. I want to first of all thank both of you and as well as your clients for agreeing to participate in this Zoom oral argument. Due to the state of affairs, we believe that this is the best way to conduct oral arguments. Let me restate that. It's the best way under the circumstances to conduct oral arguments. We certainly don't want to expose anybody to anything they don't need to be exposed, and we believe this is the best way to work it. Both of you are experienced practitioners, and just want to remind you that we will be observing the same protocol, the same procedure, and the same rules as if we were all standing in the courtroom today. Each side will have 15 minutes to make its oral argument. If you're the appellant and you have reserved oral argument with Mr. Hibner before, then you'll get that rebuttal time. Obviously, the appellee gets no rebuttal time. I want to thank Mr. Hibner and his staff. They've been excellent in making the wheels turn for these video oral arguments. Also, the AOC technology staff has been fantastic. We want to recognize them as well. Before we get started, I want to introduce your panel for today. We have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case.
In re Estate of Margie Ann Johnson.
We will hear from the appellant.
Good morning.
Good morning.
May it please the court, I'm Grayson Cannon of the Sumner County Bar, and I represent the appellant in this matter, Laura Hamilton. This case concerns a petition that was filed by the personal representative of an estate, which was titled for judicial reformation of deed or to divest real property out of estate of the deceased and into trust. The basic factual background is that the decedent, Ms. Margie Ann Johnson, was the subject of conservatorship prior to her death. In addition, prior to entering into the conservatorship, Ms. Johnson had a revocable living trust. The only asset titled to this revocable living trust was Ms. Johnson's residence, which I'll refer to as the Biggs Road property. When the conservatorship was instituted, the pleadings to open the conservatorship and request the appointment of a conservator made no mention of the revocable living trust. The property was referenced in the petition as belonging to Ms. Johnson. During the course of the petition for conservatorship, the guardian ad litem's report did mention and bring to the attention of the court that the property was actually titled to a revocable living trust. But there was no mention of the trust's ownership of the property anywhere in the conservatorship petition, nor in the order or the property management plan that was approved by the court for the conservatorship once the conservatorship order was entered. So at some point during the course of management of the conservatorship, the conservator petitioned the court to be permitted to sell this Biggs Road property and to purchase what was termed a replacement dwelling for the ward. The replacement dwelling I'll refer to as the Jackson Road property because that was its location. The petition requesting permission to sell the Biggs Road property and purchase the Jackson Road property also made no mention of the revocable living trust, even though apparently the property was still titled to the revocable living trust at that time. The court entered an order in the conservatorship permitting the requested sale of the Biggs Road property and authorizing the purchase of the Jackson Road property. In the order, there is no mention of the revocable living trust. The court's order permitting the sale directed that the conservator has the authority to sell the property and to purchase the Jackson Road property, quote, on behalf of the ward, end quote. There is no mention whatsoever of the revocable living trust. When the Jackson Road property, the replacement dwelling, was purchased, the closing agent prepared and recorded a deed of the replacement property to the conservator as conservator of Ms. Johnson. There was no mention of the trust. The title to the property was clearly placed squarely in the conservator and not in the trust. Subsequent to this, somewhat less than a year later, the conservator again came to the court and by motion requested permission to be able to incur a mortgage on this property for the benefit of the ward, to pay the ward's ongoing living expenses and to provide for the care of the ward. Again, no mention of the revocable living trust. The court permitted the conservatorship to mortgage the property in order to defray the ward's living expenses. So that mortgage was also done. Then several years later, the ward, Margie Ann Johnson, died and her estate was opened in the probate court. And that estate was intestate. The petition asserted that no will of Ms. Johnson could be found. So the intestate estate had 3 beneficiaries, Ms. Johnson's 3 daughters, one of whom has subsequently predeceased, leaving 1 child of her own. And at this point, the personal representative filed this amended petition in the estate, alleging that the manner in which the replacement dwelling, the Jackson Road property, was titled, in other words, to the conservator, was a mistake of fact, and that this deed should be reformed. And in fact, the court should transfer ownership of the property from the decedent's estate, where it lay, because it had been titled to the decedent's conservatorship at her death, and back into the revocable living trust that the decedent had set up prior to entering a conservatorship. The appellant has raised 2 issues for consideration by the court. The first is essentially one, I would submit, of jurisdiction, of subject matter jurisdiction. We phrased it as the court lacked authority to act on this real property. And the basis of that assertion is that under Tennessee law, a personal representative doesn't acquire title to real property of an estate unless certain situations first exist, none of which appear in this case. First, possibly, the intestate estate could be insolvent and a petition could be filed to determine insolvency and to sell the real property. Or there could be a will permitting the personal representative to act upon real property. Neither of those facts pertains here. So we would submit, because there was no showing or finding by the trial court that the personal representative could exercise any power or authority over the decedent's real property, then the trial court also lacked authority to act on the personal representative's petition to modify title. I would submit that this is an issue of jurisdiction and is not therefore waivable, and thus it can be brought at any time. I would agree with the appellee's contention that we did not raise it until the appeal. However, I would submit that we are still permitted to raise this issue because it is in fact jurisdictional. The second assertion that we have made is assuming, for purposes of argument, that the trial court did have some ability or authority to act upon the real property of the decedent, that the personal representative has not met its burden of proof here in order to permit the court to reform this deed. This is a situation in which mutual mistake has been alleged. And I would submit under the case law, under the Sikora versus Vanderplug, case that I cited in my brief, there could be 2 avenues in which to reform. One could be mutual mistake. The other might be some type of unilateral fraud, but there's been no allegation of fraud here. So what we're considering is mutual mistake. And the only proof that was presented at trial was that the conservator alleged and asserted that there had been a mistake in the way the drafter drafted the instrument. However, the deed itself makes clear that it's being done pursuant to the court's order. And the court's order speaks that this is being done for the benefit of the ward and on behalf of the ward. So that's the manner in which the preparer of the deed actually titled the real estate to the conservator. No proof was presented regarding the intention or the thought process of any other party to the deed. There was no proof regarding the drafter. And so we would submit that there was insufficient proof of mutual mistake to begin with. Most importantly, this particular type of action, reformation of a deed, requires clear and convincing evidence. I would submit to the court that here, not only is there not clear and convincing evidence, there is no evidence of a mutual mistake. And therefore, the trial court could not act because the grounds were not proven by the petitioner.
Ms. Cannon, let me ask you, you said no evidence of a mutual mistake. Would that principle of law even apply here where you don't have a dispute between parties to a contract?
Yes, I think it would. I mean, I would submit that there has to be some proof of some type of error or misunderstanding in order to reform the deed.
Well, did Ms. Hobdy testify that the closing attorney was instructed to place the deed in the name of the trust? And was there any proof to the contrary?
She testified that she thought she had told them that, and that she believed she had asserted that. And as to your question, no, there was no proof to the contrary. Have I answered your question, Your Honor?
You have, yes.
All right, thank you. So I would submit in this case that there was insufficient proof for the court to engage in this action and reform the deed.
All right, thank you. You used your initial time. You have your rebuttal time. We will hear from the appellee.
Good morning, Your Honors. My name is Philip Kelly from the Sumner County Bar, and I appreciate the opportunity to argue before this court. I think this is simply a case of a mistake that was happened as to how the property was held and how it was conveyed after Ms. Johnson became incompetent. We've alleged in our brief really states our position quite clearly. There was a trust that was set up by Mr. and Ms. Johnson in 1996. It was amended 2 times, one after Mr. Johnson died. And in that, they changed who the beneficiaries was and how the trust, the residuary of the trust was to operate. But in the 1996 trust, which was not modified, they explicitly excluded their daughter, the appellant here, from enjoying it.
Why does that matter? Why does it matter that they were excluding the daughter in the trust? That's really not the issue before us, is it?
No, it really isn't. No, it's not. The issue before this court is whether or not the deed should have been conveyed back to the trust or to Ms. Hobby as the trustee of the trust. The court is correct on that point. So what happened was the property was in the trust. Ms. Johnson, it was required that a conservative would be appointed for Ms. Johnson because she was doing certain things that was not in her best interest. So this court, the Chancery Court here did appoint a conservative, which was also Ms. Hobby, who was the successor trustee of the trust. In that, it became necessary and convenient at the conservatives' request that the property owned by the trust be sold and that a new property be purchased, which was close to where the conservative lived to take care of her mother. And that was approved by the court. Now, as Ms. Cannon stated, it was in the guardians ad litem's report that the property was owned by the trust. And the court didn't pick up on that. And quite frankly, the conservative did not emphasize that to the court. She was interested in getting a permission from the court to sell the property and to reacquire a house that was next to her. And that was done. It was done on the same day that she conveyed the house on Biggs Road and the same day that she bought the property on Jackson Road next to her. Now, the conservator certainly was not schooled in the sense as to how the deed was to read that she purchased. And we were not involved in that purchase. That was done by Smith Scholler, which is an outstanding real estate firm here in town. Now, the testimony, which was not contradicted, that the conservator told the attorneys closing the transaction that it was to be conveyed back in the same way that she sold the property. And in that she sold the property as trustee and conservator, naming the trust. Now, Ms. Cannon said, well, there was no proof that was put on. However, we alleged that in the petition for reformation, and she certainly had the opportunity to either talk with the attorneys or talk with these sellers from that point of view to see if there was any type of mistake here. It wasn't. There was no contradicted testimony other than the closing attorneys who represented both the buyer and seller failed to heed those instructions and conveyed it back to her as conservator only. She did not know the difference, did not catch the difference until Ms. Johnson died and her estate was being probated. It was at that time that we learned that the real estate was not back in the trust. So our position is, though legally the conservator had the title to the property, our position is, and this came out of the Court of Equity, that the equitable title was with the trust and not with her as conservator. Now, the law is very clear that the court is to look at the intent of the trustor. And Ms. Cannon really doesn't raise that as an issue. Well, what was the intention of the trustor and the trust? And I think the court must look at that. And during the trial, the Chancery Court here realized that there was a mistake in how the property was titled. And he did order that the deed be reformed for the title to go back into the trust. The trust is still a viable trust. It's not been terminated because there are beneficiaries. There is the course of the trust is to go to a preaching school after both of the current beneficiaries pass away. Now, you have to look at it in terms of the conservator here. She was appointed the conservator. She was also the substitute trustee. But if the title to the property stays in the estate, she stands to inherit 1/3 outright. So she's saying that the deed should be reformed back into the trust, where she's not going to get the benefit other than being an income beneficiary over what income could be established or earned from the corpus of the trust. So she realized what the purpose of the trust was. She knows what the intent of the trustor was, and she could benefit by just not doing anything, just letting it go like it is. But she knows what the intent was, and she says that the deed should be reformed so that that becomes the asset of the trust, and that the terms of the trust be carried out. That's what our position is. And the Supreme Court bears that out in the Gold case. The court says you do look at the intent and the purpose of the trust. And I think the court here, as an equitable court, has the duty and the jurisdiction to do what should have been done that was not done in the initial circumstances. Basically, what it boils down to, Your Honor, that had the deed listed Kathy Hobby as conservator and trustee, we wouldn't be here today. We're only here because of the mistake of the closing attorney, and it was an honest mistake. But that's the reason that we're asking the court to affirm the decision of the chancellor. He was in a position to look at the credibility of the parties. He was in a position to look at the trust and what happened. And I feel like that his decision was correct and should be affirmed in this situation.
Mr. Kelly, did the Sunset Bible School actively participate in the suit to reform the deed?
No, they have not. They're just, they're the ultimate beneficiary of the trust, and they have not taken an active position in terms of course, they've been kept informed of what's going on. They have been kept informed with the pleadings and that type of thing, but they have not come in to seek independent counsel with this, because Ms. Hobby took this upon herself as a conservator to correct the mistake that was made and as being the substitute trustee. So that
Anything
really,
further? I'm sorry, go
well,
ahead.
that's really my argument. As I said, I think that our brief states it with the authorities. And as I just want to emphasize again, I think the Court of Equity has the duty to correct and to do what equity demands in this case, which was clearly a mistake. And we're just asking the court to affirm that decision to allow the deed to be reformed so it goes back into the trust where it should have been in the beginning.
All right, thank you, sir. We will hear the rebuttal of the appellant.
Thank you, Your Honor. Briefly, and I do want to return a little bit to Judge Armstrong's earlier question because he was asking me about the testimony that Ms. Hobdy gave, the former conservator. I would submit that really, because she was acting in her role as conservator here, what really matters is what was the court's impression of what should have happened. As I pointed out in my brief, a court speaks through its orders, and the orders of the court here clearly intend to act on the real property for the benefit of the ward and the conservatorship, not necessarily the trust. The party here was the conservator in her role as such. So she didn't necessarily have any authority here to make a decision about how the property.
Hold on just a second, Ms. Cannon. Let me ask you a question because you're confusing me.
Sorry.
I thought you said the party was the conservator here. Is that correct?
Yes, to the underlying transaction. Yes.
Okay. The administrator filed this lawsuit, correct?
That is correct.
Okay. And essentially the administrator is saying, court, tell me what to do. We got two people who are saying, or two different entities that are claiming ownership of this property. So as far as the conservatorship, I'm assuming has been finalized and it's over. Is that correct?
That is correct.
Okay.
That is correct.
All right. But you were just confusing me using your terminology there. I'm sorry. Go
I'm
ahead.
very sorry. When Ms. Hobdy testified in the proceeding, she was testifying about her participation in the transaction to purchase the replacement dwelling, which she had done as conservator of Ms. Johnson. And so during that time, when she was a party to that transaction, she was acting in the role of conservator. And that's what I was referring to.
Okay.
Ms. Cannon, the trial court's order doesn't order the Jackson property to be placed in the name of the conservatorship, does it?
No, it does not.
It doesn't really address how this new property is to be titled. It simply gave Ms. Hobdy the permission to sell Biggs property and to acquire the Jackson property without any reference to how it was to be titled.
Well,
Is that right?
I hate to give you a mixed answer, but I would say yes and no. While it didn't expressly say title it to the conservatorship, it said that the property, and I quote, the use of the words in the order, was to be purchased on behalf of the ward. That would imply that it was being done on behalf of the conservatorship, not on behalf of some type of trust, and not for any other purpose.
Well, if it was done on behalf of the ward, it could only, the ward's interest, if whatever interest the ward had would be the interest that the court was referring to, correct?
I would presume so.
Okay. And what was the interest of the ward in the property at that point in time?
The property prior to this transaction was titled to her revocable living trust.
Okay. So whatever interest she had before would be the interest that we're talking about, I'm assuming. Would that be correct?
Well,
Whatever interest she held at the time that she became a ward. That's the only interest that the court could affect.
Correct. However, I would submit that the case law does permit the court to act on matters of this type, especially where the living trust, as here, was revocable. The ward would have possessed the power to revoke the living trust at any time during her lifetime.
But did the court ever address that?
No, it was not addressed in the court's orders.
So
Was the ward competent to revoke the trust, Ms. Cannon?
Not at the time of the transaction. However, I would submit that the court could have acted for her if the court felt that revocation of the trust was in the ward's best interests.
are you saying that that's what the court did?
I'm saying it appears that that's what the court intended to do. Yes.
Okay. Judge Armstrong, anything further?
Nothing further.
Okay. All right. Thank you so much for participating in this oral argument. We will obviously take this matter under advisement and render a written opinion as quickly as we can. We again thank you for your participation. And Mr. Ebner, anything further we need to take up before we recess for the next case?
No, Your Honor.
All right. You may recess until the next case.
This honorable
Thank
court is now in recess until 10 a.m. Oh, you guys got a fun one there.
Are we off, Jim?